Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law, and today's guest is U.S. District Judge in the Western District of Texas, Xavier Rodriguez. And I am fortunate to know Judge Rodriguez because he teaches our students and has been since before I became dean. We're so lucky to have him as part of our adjunct faculty. And today we're going to be talking about Judge Rodriguez's work with studying technology in lawyering and AI and the challenges with data. So I'm so happy to have you as a guest.
Oh, thanks, Dean. Appreciate it. This is going to be fun.
Well, you have been on the bench since George W. Bush appointed you in 2003, and what differences you have seen in your job since then and the practice of law. So maybe we can start by talking about when you first started to notice technology really changing things in the practice of law and in your role on the bench, and what prompted you to explore how this was all going to work further.
Yeah, so I was with a big national law firm prior to getting on the bench. And before this job, I was on the Texas Supreme Court for just a short little stint. And before I got this job, it was about a year delay in me getting here. And so I went back to my old firm, and I'm going to try to answer your question here. While I was there, I got assigned to an arbitration in a pretty big case. The arbitration matter went to a mediation beforehand. And long story short, the allegation against our client was that they had botched this trials that were going to get FDA approval, and the number of participants in this clinical trial were at issue. And my client's defense was, no, we talked to our client about this, and they agreed that they wanted to go with this lesser number of clinical participants because it was going to be too costly. They agreed to this. We told them that may not be enough participants to get FDA approval, and they said, no, let's go for it. And so we did. We tried finding the email. This is 2002, and we tried finding that email and, of course, never found the email.
Oh my gosh, this must have been doing it by hand, lots of boxes.
We are searching every computer that anybody might have touched, and that whole process made me start thinking, there's got to be something better because this is the direction the world is going to. No, even there, that was sort of the start of fax machines were still being used back then, and so this was sort of the start of actually communicating via email. And so that case, and I can't believe how much we settled that case for, but led me to this lifelong interest of technology. Also, it helps that I have an identical twin. He just retired. He was the chief technology officer for a hospital chain up in Ohio and Kentucky. And so the geek runs in the family, I think.
Well, he must be a great person to bounce some of your questions and ideas off of, that's for sure.
Well, he was, but he hates lawyers.
Well, I know you've been teaching electronic discovery for our students, and it makes sense. This prompted a lifelong interest in that. And now that's not even new, right? That's been with us for a couple of decades. But the privacy issues, the cybersecurity challenges, and now AI are really opening up a brand new frontier. And I've enjoyed listening to you before when you've talked about some of these issues. So where are you seeing it as a judge in the Western District of Texas? Where are you seeing this kind of technology come into your courtroom?
Yeah, it comes in all forms of fashion. The most, if we're talking about just sheer quantity, is of course just text messaging. But now we're faced with not just text messaging on phones. People are using ephemeral or disappearing apps. And that's yet another challenge on trying to get the information. And then what inferences do we draw when people are using these disappearing apps? We're seeing it both in the civil space and the criminal law cases. So yeah, cell phones is where the evidence is at. By and large, I think we sort of understand the cell phone evidence, how to extract it, if we can extract it, where some of the data is located. The harder challenges we're now getting to, though, a lot of, post-COVID, everybody started using Teams and now Slack, and there's a whole bunch of collaborative apps out there, and the challenges now of extracting information that may be relevant to a primarily civil case has a lot of challenges there. And there's some challenges that have just been ongoing that we haven't figured out yet. I got convinced to write a law review article, and I'm still working on it. The deadline's coming pretty quick, so I need to get going. But possession, custody, and control. It's just amazing how our rules just haven't kept up with all this. The phrase is in Federal Rule of Civil Procedure 45, but it's not defined. And so courts have developed different interpretations of, we understand possession, we sort of understand custody, but the word control, what do we mean by that? And so two differing strains have come out in the courts. One is called the practical ability test, and the other one's the legal right of control test. And I don't like either one. So I'm trying to come up and see if I can go back to agency principles, and that's what the law review is going to be about. But with the challenges of mobile devices and a whole bunch of other platforms, we really need to get that figured out.
Absolutely. So you talk about disappearing apps, and I can remember when people thought, if with Snapchat, I think it was, your pictures disappeared after a certain period of time. And of course, we came to find out, no, they're somewhere. And so with these disappearing apps, does that material exist somewhere, or does it truly disappear?
These platforms do have the ability to set retention cycles. But one of the retention cycles and the default for a lot of these platforms is disappearing. Yeah, we're seeing this being used a lot. We're seeing it being used in the criminal cases. People, involved in their drug conspiracies using this. We're seeing them in the theft of trade secret cases. We're seeing in violation of non-compete or non-solicitation agreements where everybody's using these devices to communicate and get around those. They truly are gone, which is why we sort of need to figure out, well, what inferences are we going to draw by the use of these apps? And do we draw a different inference once litigation has begun and the app has continued to be used? You might ask yourself, well, how do we know that, right? Because it's gone. And sometimes in depositions, it'll come out that, oh, no, we continue to discuss. One party or another may take a snapshot of their cell phone. And so now we got proof of use. Sometimes they're gone. Sometimes old-fashioned screenshots save the day.
Well, I thought that was interesting, and I was going to ask you about that. Are you permitted to draw an inference from the use of those under the law right now?
For a lot of judges, it sure doesn't pass the smell test. And so, if that's a formal inference, probably not. I speak a lot on continuing education programs, and I've got a lot of friends in this space. And we have a good, hearty discussion about just these devices. A lot of them are convinced that it's legitimate business use purposes with enhanced cybersecurity measures in place, and that's why they're using them. I don't know. I'm not convinced that it passes the smell test. Whether or not we can use an inference, well, if there was a duty to preserve, and then we do actually have maybe a screenshot saved of this, that would probably constitute spoliation. But prior to the duty to preserve being triggered in litigation or regulatory purposes, it's probably okay to use. You don't have to preserve anything if you don't have any duty to preserve. But I don't know. It's making employment cases, theft of trade secret cases, non-compete cases a whole lot harder.
It sounds like it. My goodness. Now, as far as lawyers using tech currently, what do you find the proficiency of the lawyers practicing in front of you and your audiences when you're giving these presentations around the world to be? Are lawyers slow to the table to start using all of these new tools? Are the majority of them jumping on board?
Lawyers are slow to adopt, right? I'm old enough to remember when fax machines came out, we all fought about fax machines. Oh my goodness, is your duty to preserve confidentiality going to be breached because somebody passing by the fax machine might have seen this document? And then we got over that. And then we started fighting over Blackberries. And then we started fighting over emails and whether we could communicate with our clients over emails. And then we fought over cell phones. And then we fought over, can you store your data in the cloud? And so we're always trying to find a way to not adopt technology. We're always
That's not working out, is it?
Yeah, and it's not working out. That's why I get so frustrated with some of this, right? It's not going to go away. We're not going to win this battle of ignore it, beat it off, because that's going to fail. Some lawyers are still trying to do that, right? We've seen a whole bunch of mishaps on a variety of fronts. We see still a lot of traditional spoliation cases because lawyers, even after well, I'm losing track of time. Let's see, how long? 15. So, the latest iteration of federal civil procedure rules is going on 10 years, and the earlier version was 5 years before that. So we're roughly at 15 years, and lawyers still don't realize what information needs to be retained, how it can be retained, where it's stored. And so we have a lot of lawyers just not understanding basics. We got some on the other end of the spectrum, I think, overcomplicating things, right? We got a lot of great tech lawyers in this space. And they sort of push, so, well, you got to save everything, retain everything. If you don't, you're going to be negligent. You should be sanctioned. And so, I don't know, I guess I'm more like Goldilocks, right? There's got to be some little medium space here where we all can navigate. Teaching lawyers is tough, but me and various others have been trying to do it for the last 10 years. And some want to receive the message and adopt it, and others still we'll turn it over to young associates like, they know what they're doing. And just because they're young doesn't mean they know what they're doing. It's all over the spectrum.
And I know that in your management of your docket, litigation now has become just extraordinarily complicated with all the data that you can obtain. So it's not the boxes and finding that one email in your hard file, but you can get all of the information from the cloud during discovery, and that gives you tremendous amounts of information you have to sort through. So the lawyers have to sort through it, but then you as a judge have to sort through it too. So how do you address that voluminous data as a judge?
I'll tell you how I'm sort of doing it. I'm doing it cautiously because although I like to be sort of innovative in this space, I don't want to be too far out from the comfort level of the judiciary as a whole. I'll tell you about an experiment I've done and then other things I'm doing. So lawyers are having to deal with a whole lot more data. Data is just being driven constantly. It's increasing. It's in a number of different data sources. There are many more custodians. So lawyers have challenges, but then they dump it all on the judges. And so we get reams of data. I'm playing around with about 7, 8, 9 different AI tools right now. Some are early e-discovery products. And so I'll use some of them just for the purpose of finding documents. Our platform in the judiciary is not such that I can type a keyword across the whole spectrum of data and find documents that way. Our CMECF system is not structured that way. So what I'll do is I'll upload all the documents in a case, put it up in one of these tools. I can do old school. I can just do keywords, or I can use some of the AI tools that are out there now. And a couple of them are very interesting right now that are being developed. One being developed just for the judiciary was adopted by Minnesota. It's pretty cool. It's got a great name. It's called Learned Hand. I'm not endorsing tools. I'm just describing what I'm playing around with.
Oh, that is a very cool name.
It is a cool name. But there's a number of other platforms just like this. You upload your file. You can run prompts against the entire database. This one tool, Learned Hand, all you do is push one button, summarize. And, it's good and bad. You got to be careful about how you're using this stuff. It's not final product. But, I'll give you an example of what I did. I had a motion to dismiss an indictment about 4 Honduran nationals claiming that they weren't involved in any drug conspiracy to bring drugs in the United States. If they were doing drugs and if they were selling, it was only for domestic Honduran distribution. And so they challenged the extraterritorial application of these American drug laws. I uploaded the motion to dismiss the indictment, the brief, the government's response, the reply, hit one button, summarize, and it did a bench brief with all the relevant issues played out. Now, it's great for a first draft. We got to be careful about it, right? Is it leading me astray? Is it skewing me in a certain direction? You always got to be cognizant of stuff like that. And am I going to be over reliant on that? You always got to check yourself on stuff like this. And you use it as a draft. You double check all the citations that they actually exist, that they actually stand for the proposition that was cited. I always just use these things as draft, though. I would never go into these as a final product. But 3 or 4 judges around the world have acknowledged that they've used these kind of platforms for their final opinion. I don't think these platforms are there yet, my personal take. But, they're a very helpful first draft. I had another case where 7-week trial, 77 witnesses, hundreds of thousands of pages, if we ever had to print them out. I had just boxes of documents in my office, and we couldn't even find things. And so I had one of my vendor friends in my e-discovery class there at St. Mary's. I get all these vendors to lend me their products for my students. And so I treat these students as first year, second year associates, and I get them to play around with these e-discovery tools and give them exercises, requests for production of documents. And I have them basically acting as a first year associate in identifying responsive documents, doing a privilege review. So I turned to one of these e-discovery vendor friends of mine, and he lent me his AI platform. His is a more sophisticated, large base platform. We uploaded the entirety of that file. It was huge. There was over 1,000 something CME/CF entries. If I had to pay for that, God, it would have been a fortune. But we put it all up there. Now, don't get me mistaken here about what I did. So me and my staff I had to do findings of fact and conclusions of law. It was a bench trial. We did it the old-fashioned way. Eyes on paper, keys on keyboard. And after about 10, 11 months, we produced a 150-page opinion on this case. After we released it to the clerk's office and it went public, then I turned to this program, and it's called Merlin, another cool name. These guys have got cool names. So we turned to Merlin, and we probably did 3 iterations of a prompt, had to call Merlin staff once for help. Merlin doesn't do typical legal research like Westlaw Co-Counsel or Lexis AI Protege does. So all we were able to do on this platform is the findings of fact. But with 3 iterations of a couple prompts, it turned out 55 pages. I wrote a little article for Judicure magazine. It'll be coming out in a little bit. And ultimately, the conclusion was pretty nice first draft. Was it a draft? Yes. Was it final? No. Did it mess up a couple of times? Yes. Were some page numbers off on a couple of points? Yes. But, what I go around teaching my colleagues about these tools are, guys, we're being inundated with data. Our poor state judge colleagues don't even get law clerks in most instances. And so we've got to find ways of expediting our work in a responsible manner. And I think these tools can help us get there.
That's pretty cool. I love that you did that experiment after you had done the work as humans, right? But certainly it can be helpful. I get so frustrated by the news that talks about, the hallucinations that lawyers had in the briefs they submitted or whatever. Check your work, right?
It's not rocket
It's
science.
not rocket science. It's not an AI problem. It's a lazy lawyer problem.
Yeah, I think, and well, some of these lawyers have been messing up kind of surprised me, but I bet you these, in most respects, are the same lawyers who had paralegals or law students do their work and they just signed without doing any independent review. Now it's being caught because now there's AI hallucinations that, can catch this pretty easy. My running joke on the speaker trail is lawyers have been hallucinating well before AI. And
That's
so,
right.
yeah, some of these judges are way overreacting to this. This is an education problem.
Yes, it's interesting. I love where, judges say you have to disclose that you've used it, this, that. We didn't have to disclose when we used Lexis and Westlaw or when we shepherdized our cases through them. So it's interesting. There's a learning curve, a comfort level that the judiciary and profession will have to reach. Where do you see AI use in the kinds of examples you've given, say, in 5 years from now? I mean, now we're doing drafts, or they're coming up with drafts that you think are usable and that are final for a few judges worldwide. Where do you see that progression?
Yeah. So, hard to predict, right? I've heard a CEO give a talk. This is a CEO of an AI product. And I was kind of surprised because normally like a CEO will market up his product, right? And rah, rah, rah. And there wasn't a lot of cheerleading here. And his thing was, okay, well, hopefully we're going to see great improvements, great strides, a lot of cleanup on hallucinations and other factors. But this is the best it gets. Well, that's pretty dang good. And I thought, wow, that was awfully honest. I'm hoping we get better than just okay. We're here at a pretty good spot. If AI usage in other fields are any indication, though, I think we're going to see great improvement. The use of AI in the medical field has been astonishing. It's detecting early cancers at a better rate than radiologists. So I'm kind of hopeful. I think we're going to start using these as bench memos. We'll have to still check probably for having a skewed analysis and we over rely on it. Frankly, we already have that problem right now with law students, law clerks. They've got their own ideas about where they want to see the world end up. And so I've always got to be in constant check about where my law clerks might want to push me. So I don't think this is any different. And now, are we going to see AI usage? I think at some point, though, the public sector is going to push back on some of this, right? I don't think they're going to be all that thrilled with AI usage in sentencing or bail determinations, although a lot of states use AI products for that. I don't know. That's law and judging is not so much a science. And, there's just a lot of discretion. And I think that's still got to have a role in our judicial realm. So, yeah, I don't see AI taking over completely here. So I'm cautiously optimistic that we're going to try to get to just speedy and inexpensive and in a fashion here. We got to bring down these costs. We've pretty much beaten down the civil justice system. It's just too expensive, and a lot of players have opted out. We've lost a lot of cases to arbitration, and now we're less than 1% of civil cases going to trial. And I think a lot of this is cost-driven, and so hopefully we can overcome that with AI.
So, in having this conversation, an idea came to me. I wonder if the judiciary could put the burden of the AI usage and the summaries on the lawyers. So, the lawyers summarize through AI. They review, they proof, they turn it in, and then the judges get the summaries and have to work from there. Maybe that's a way to go.
Yeah, maybe. I don't know. For half my cases, I hate to say it, but we can't even rely on the briefs and the motions, and we're just better off, at least for legal analysis. I'm not talking about facts. Judges are bound by whatever facts are brought to us. But sometimes for the legal analysis, we just have to start on our own, ditch both the briefs, and start from scratch.
Well, I'm certain that's not with what St. Mary's attorneys are submitting, but but that's a pretty sad state of affairs. You mentioned that some of these tools are cost prohibitive, and certainly for lawyers starting out now, maybe young lawyers in a small firm or even big firms that are questioning what to do. I don't want to make you do a commercial or anything like that, but you mentioned Lexis and Westlaw, which of course are the main legal research tools that lawyers have been using for decades now. How do you find those tools to be? Do you think that those are tools that lawyers should consider using at this moment with AI?
So, I've been playing around with 9. Those are 2 of the 9. Some of it comes down to just comfort levels, right? Some of us grew up on Westlaw and we're sort of into that product. Some of us grew up in Lexis and we're into that product. And so a lot of ways, one thing I wish I had the time to do is I wish I could really do a deep dive into all 9 and do a comparative analysis across all 9 and determine which one works best for some specific use case that I'm doing. Some do chronologies, I think, a lot better than others. AI does summaries pretty good. And then legal research is another matter. Now, I haven't done it, and I don't have time to do that kind of analysis. Wish someone could do that analysis for us. That would be helpful. But at the very least, I think what lawyers need to be doing is whatever AI tool you use, when it does its response, you got to check its response for accuracy. And I would not actually check the accuracy with another AI tool. I would just go out of the AI tool, go into traditional Westlaw or traditional Lexis or whatever other platform you might be using, type in the case, find out if it's a real case. Then you have to still read the case and ensure yourself that it actually stands for whatever proposition the response is giving. You have to get out of the tools right now. Hopefully in 5 years we won't have to, but you do now.
Well, thank you. That's good advice. And as long as we're talking about 5 years, let's look at 10 years. And let me ask you, legal education is certainly having to identify how we are going to teach our students about AI and the professional and competent and ethical use of it in the practice of law. Where do you see legal education in the coming decade in any area, AI or otherwise? How do you think it will
Yeah.
change?
Here's my hope. I want to see us, and it runs counterintuitive. We all went to law school because we didn't want to do science. But I think we're going to have to be a lot more scientific in orientation. We're going to see AI thrive, and we're going to need to make sure our students understand AI and how clients are using AI. That's going to be number one. Then there's going to be other technologies that are going to be developing cryptocurrency. I still don't understand the enthusiasm for it, but it's here. We're going to need to understand, is this an equity commodity that needs to be regulated? We're going to need to understand it just for financial evaluations of divorces. We're all going to need to understand that. We're going to need to understand just developing sciences. I got an LLM recently from Duke, and our professor, Nina Fahrenheit, had a really interesting little hypo she worked from. Brad Pitt checks into a hotel. One of the cleaning crew ladies waits for him to check out, goes with her next door neighbor, DNA expert, and they swab up his discarded DNA. She then gets herself impregnated with the discarded DNA from Brad Pitt because she's hoping for a good looking kid.
Oh
Uh,
my.
she gets impregnated. And so that technology exists already. And then her question that she posed to us is Brad Pitt liable for child support? This is the kind of world we're stepping into here in short order. And it's going to be a lot more scientific and technical in orientation than we've historically been giving out in law schools. And I think we need to start gently reorienting ourselves in that direction.
Fascinating and a little bit frightening. The hypo and the implications for law school. Well, thank you, Judge Rodriguez, for sharing some of your insight with us about the technologies that are developing for the profession and the judiciary. If you enjoyed this conversation and would like to listen to additional thought leaders in legal education and the profession, please check out Aspen Leading Edge podcast on their webpage and also your favorite podcast channels. Thank you.
Thanks, Dean.